thing to remember is that private nuisance requires a substantial invasion of right. This is one of those cases where the old proverb, de minimis non curat lex, which means the law does not concern itself with trifles, applies. If the interference with the plaintiff's right was minimal or trivial, the law will not regard it as a nuisance. For example, every day at noon, the factory on the other side of town cleans out its machines and puffs for one moment a bad smell into the air, and then the bad smell goes away in a moment. And all the plaintiff would really have to do is close his window every day at noon for about 30 seconds, and the bad smell will be gone. He can open his window again. It may very well be that the court would decide that's not a serious enough invasion to be called a nuisance. Not only does it have to be something that seriously discommodes or seriously inconveniences the plaintiff, it's got to be judged by an objective standard, which means it's got to be something that would seriously discommode or inconvenience the ordinary person in the plaintiff's shoes. There's a case that was decided, and it's not a very important case except for the point it makes, about a woman who was recovering from some disease or recovering from some surgery, and she needed to sleep a lot during the day. And she complained that whenever the church in town rang its bell, which it did every half hour or something, that disturbed her rest during the day. And she called it a private nuisance. And the court came to the conclusion that the ordinary person in her position would not have been seriously inconvenienced or seriously discommoded by the ringing of the church bell for a moment every half hour during daytime. And the court concluded that as a result, there was no private nuisance. Now, here's something to think about. When I'm claiming that the defendant is doing something which interferes with my right to use and enjoy realty, if I win my case, the court is going to either make the defendant stop doing it or make the defendant pay me for doing it. And in effect, this may stop the defendant from doing whatever it was that interfered with my right to use and enjoy realty. And won't that interfere with the defendant's right to use and enjoy realty? If you can see that, you can understand why most of the time in a private nuisance case, the court performs a kind of a balancing and tries to decide, in effect, whether the plaintiff's rights are more worthy of protection than the defendant's, or whether the defendant's rights are more worthy of protection than the plaintiff's. So some of the factors that the court is liable to consider are: how much would it cost the plaintiff to protect himself or herself against this invasion? How much would it cost the defendant to protect the plaintiff against the invasion? Would making the defendant pay for the interference put the defendant out of business? How important is the defendant's business to society, to the defendant itself? How important is the plaintiff's activity which is being interfered with? The plaintiff says, I can't listen to the ball game on TV because that hospital next door keeps running ambulances in and out with sirens going. And a court might say, well, gee, operating a hospital is much more important than allowing the plaintiff to watch the baseball game. And so we decide that this was not a nuisance. The court balances all of the equities, all of the rights, all of the burdens and benefits of the defendant's conduct and of protecting the plaintiff's right in deciding whether a nuisance has taken place. There's a case, Amphitheaters Incorporated is the name of the case. Maybe you've read it, maybe you're going to read it, about a drive-in movie theater that was located next door to a racetrack. And the drive-in movie theater complained that when they had racing at night, the lights from the racetrack interfered with the drive-in movie theater because people couldn't see the screen. There was so much light coming from the racetrack that they couldn't see the screen. And the plaintiff said that that was a private nuisance because the lights from the racetrack were interfering with the plaintiff's right to use its realty for business. And the racetrack said, well, if you make us stop doing it, that'll interfere with our right to use our property for business. Now, some people might say, well, why not just put up a fence between them that would block the light? And I guess that would be all right, but now the question is, who should have to pay for the fence? The drive-in movie theater or the racetrack? Well, in that particular case, the court solved the problem by saying apparently the evidence indicated that the light coming from the racetrack was only as bright as the full moon, and it was only on for about 2 minutes 9 times a night. And the court came to the conclusion that that was not a substantial interference with the rights of the drive-in movie theater, that it was trivial, that the ordinary person making ordinary use of the land would not have been seriously discommoded by it. And that was how the court disposed of the problem. I mention the case because I want you to see the need for balancing. I want you to see what a difficult question this can be. And when you read those cases in which courts talk about whether a supermarket should have been in the neighborhood, should not have been in the neighborhood, remember that what the court is doing is balancing society's needs, the defendant's needs, the plaintiff's needs, the burden to the defendant, the burden to society, the burden to the plaintiff, and all of those factors that might help the court decide the fair solution to the problem. So in a way, the law of nuisance is kind of amorphous because remember, nuisance is not so much the name of a tort as it is the name of a damage caused by a tort. The law of nuisance. Let's talk about a family of torts involving the misuse of judicial procedure. The first of these is known as malicious prosecution. And malicious prosecution can be defined in terms of 4 or 5 essential elements, depending upon what jurisdiction you're in. Now, one of the things about discussions of malicious prosecution that gets confusing is this. The person who is suing for malicious prosecution is properly called a plaintiff because, after all, he or she is suing. But the reason he or she is suing is because somebody brought a proceeding against him or her. And in that proceeding, this person was a defendant. So it gets real confusing when we talk about plaintiff and defendant. If you don't mind, I'm going to talk about victim. The victim in this case is the plaintiff. So here are the elements of malicious prosecution. The first element is institution or continuation of a criminal or civil proceeding against the victim. Second, final termination of that proceeding in favor of the victim. Third, lack of probable cause to bring that proceeding against the victim. Fourth, malice. And the fifth element depends on the jurisdiction you're in. Some jurisdictions assume there was damage, and some jurisdictions require proof of damage. So damage is sometimes the fifth essential element. Now let's go over those elements one at a time. The first element, institution or continuation of a criminal or civil proceeding against the victim. The only person or persons who can be sued for malicious prosecution are the persons who actually started the proceeding against the victim, the one who's now suing for malicious prosecution. The only ones he or she can sue are the ones who actually started the proceeding against him or her, or who had the choice of continuing or discontinuing that proceeding and chose to continue it. Now remember, most of the people who start or institute criminal proceedings actually are immune from liability. Prosecutors, police officers tend to be immune from liability for instituting a proceeding. We're going to talk about that kind of immunity a little bit later. So, for the most part, malicious prosecution lawsuits are brought only against civilians, people who are not law enforcement persons. The second element, the proceeding must have terminated in favor of the one who is now suing for malicious prosecution. The court would be really embarrassed if while you were suing me for something, right in the middle of it, I could turn around and sue you for malicious prosecution. What would happen if we both won? What would happen if the jury in my case decided you were maliciously prosecuting me, but the jury in your case decided you were right? To avoid that problem, no lawsuit can be brought for malicious prosecution until the underlying proceeding, that's the one that I'm complaining about, terminates. And it's got to terminate finally, not terminate subject to